A woman disappears from a 12th-floor apartment in Manhattan. Her husband says she went to Central Park to get some sun. He says he waited. He says she never came home. The police search the route between the apartment and the park. They find no trace of her. Then, more than a year later, an investigator learns about something missing from the husband's story. On the afternoon Gail Katz vanished, Robert Bierenbaum rented a small plane in New Jersey and flew it over water. He had not told the detectives that. This case would take 14 years to reach an indictment. It would go to trial without a body. It would turn on absence, fear, timelines, and one unexplained flight. This is the weight of absence, Gail Katz and the flight no one mentioned. Production note: this episode is based on public court records, primarily People v. Bierenbaum from the New York Appellate Division and Bierenbaum v. Graham from the United States Court of Appeals for the Second Circuit. Where the record describes testimony, we say testimony. Where it describes allegations, we say alleged. Where it describes the defense position, we say the defense argued. There are no invented interviews and no real person voice cloning. Source readings are dramatized court record readings, not archival recordings. Gail Katz and Robert Bierenbaum married in August 1982. The appellate record places them in a 12th-floor apartment on East 85th Street in Manhattan. Robert had graduated from medical school in 1978. He was a surgical resident at Maimonides Medical Center in Brooklyn. Gail was pursuing a PhD in clinical psychology at Long Island University. On paper, they were two educated people building professional lives in New York. But the court record does not present the marriage as stable. It presents a record of fear, alleged violence, arguments, and plans to leave. Those statements are legally sensitive. Gail was not there to testify. The trial court admitted testimony from friends, relatives, colleagues, and her therapist for limited purposes, and the jury received limiting instructions. A responsible episode must keep that legal frame in the foreground.
The court record says 11 witnesses testified about conversations with Gail between 1983 and 1985. Conversations about the state of the marriage, fear of Bierenbaum's temper, controlling behavior, threats, and an argument in 1983 during which she said he choked her to unconsciousness.
That is testimony about statements. It is not a recording. It is not an interview with Gail. But it became part of the prosecution's picture of motive, intent, identity, and Gail's state of mind. The court record also says Gail was planning to leave. On Saturday, July 6, 1985, she kept ordinary appointments. She saw her gynecologist. She made a future appointment for December. She went to her hairdresser. She met a close friend for a couple of hours. She told that friend she was going to leave her husband that weekend and that she was looking for another place to live. In hindsight, the ordinary parts of that Saturday matter. Future appointments, hairdresser, graduate work, plans, a life still arranged around tomorrow. The next day was Sunday, July 7, 1985. That evening, Robert Bierenbaum went without Gail to a family gathering in New Jersey for a nephew's birthday. According to the Second Circuit summary, he said she had gone out earlier in the day and had not returned to their apartment. At the party, the record says, he did not express concern about his wife. Later that evening, at a friend's house, he appeared distraught and called the apartment several times. He told the friend that he and Gail had argued that morning and that she had left for Central Park wearing shorts, sandals, and a halter top. Close to midnight, he called Dr. Yvette Feiss, one of Gail's friends, asking if she knew where Gail was. He told Feiss the same broad story. Argument, Central Park, not returned, still missing when he came back from New Jersey. On July 8th, Gail did not keep her regular psychotherapy appointment. Robert called her therapist and others, asking if they had seen her. That evening, he filed a missing person report.
The report indicated that when Gail was last seen, she was wearing pink shorts and a white t-shirt. He told the assigned detective he had last seen his wife at approximately 11 in the morning, that she had left to get some sun in Central Park, and that he remained at home until approximately 5:30 in the evening when he left for New Jersey.
No one, other than Robert Bierenbaum, reported seeing Gail after July 6. That sentence sits quietly in the opinion, but for an investigation it is enormous. Detectives Virgilio Dalsas and Thomas O'Malley were assigned to investigate. The week after Gail was reported missing, Dalsas left several messages for Robert. The opinion says none were returned. During the same period, Dalsas received numerous calls from Gail's family. On July 14th, Dalsas met with Robert, Robert's father, and Gail's parents. He asked Robert to narrate specifically and exactly how he had spent the weekend Gail disappeared. Robert described Friday evening. He described Saturday work, shopping, eating, and a romantic candlelight dinner. He described waking Sunday, an argument, Gail leaving at about 11 to go to Central Park, and himself staying in the apartment until 5:30 when he left for the family party. Police searched between the apartment and Central Park. They found no trace of Gail. Friends and family posted pictures in the neighborhood. Detectives contacted people whose names came from Robert or Gail's family. Robert later told Detective O'Malley that the building doorman had seen Gail leave at about 11 on July 7th. Then, during a later conversation, he said he had been mistaken. The doorman thought it was another day. O'Malley asked about the marriage. Robert said it was in bad shape and that both he and Gail were in therapy. He said Gail was depressed and suicidal. O'Malley asked if Robert had ever hit his wife. Robert said no. O'Malley asked if he had ever choked his wife to the point of unconsciousness.
The opinion states that Bierenbaum said he did not want to speak about that.
Police asked to search the apartment. In July, Robert said he would get back to them. In September, his attorney gave limited permission to search for fingerprints and anything that might help identify Gail. Investigators wanted more, but believed they lacked probable cause for a warrant. The search was limited. They found no obvious crime scene. This case would be shaped as much by what investigators did not find as by what they did. In September 1986, a district attorney investigator named Hope Martin was assigned to investigate Gail's disappearance. She learned Robert Bierenbaum was a licensed pilot. The question was simple and explosive. Had he flown an airplane on the day his wife disappeared?
On October 17, 1986, Martin learned that Bierenbaum had rented an airplane from Mac Dan Aircraft Rental at Caldwell Airport in Fairfield, New Jersey, on July 7, 1985, the day Gail disappeared.
That flight had not appeared in Robert's detailed accounts to detectives. He had told both investigators he stayed in the apartment until about 5:30. But the record says that at 4:30 he was already in New Jersey, flying a rented airplane. A forensic examination of the aircraft yielded no results. Forensic tests of 2 automobiles he was driving at the time also yielded no results. Again, no neat clue, no simple match, no recovered body, no crime scene photograph that solved everything. Instead, the prosecution would later build a circumstantial case around contradiction and capability. The lie about time, the concealed flight, the medical training, the size of the aircraft, the possibility of disposing of a body over water. In April 1987, the investigation closed. In May 1989, a torso washed up on a Staten Island beach was initially determined by X-ray comparison to be Gail. That could have changed everything. But after the investigation reopened in 1998, DNA testing determined that the torso was not Gail. The absence remained. On December 8, 1999, more than 14 years after Gail Katz vanished, Robert Bierenbaum was indicted for second-degree murder. The trial was held in October 2000 before Justice Leslie Crocker Snyder in New York County Supreme Court. It lasted 8 days. A no-body murder trial asks jurors to do something difficult. They must decide whether the person is dead, whether the defendant caused the death, and whether the prosecution has proved that beyond a reasonable doubt, even without remains. The prosecution presented a wide circumstantial record. Gail's plans to leave, statements about fear and alleged choking, Robert's inconsistent accounts, the missing airplane flight, the feasibility of disposal from a Cessna 172, and the absence of any verified sighting after July 6.
The appellate division later wrote that the circumstantial evidence, when attentively reviewed and critically assessed, led to the inescapable conclusion that Bierenbaum murdered his wife on July 7, 1985, and excluded beyond a reasonable doubt any reasonable hypothesis of innocence.
That is the court's language. It is strong language, but it came after a legal review, not before. At trial, the jury had to sit with the evidence piece by piece. The defense did not need to prove where Gail went. It needed to argue that the prosecution had not carried its burden. It challenged the admission of Gail's statements. It challenged the psychiatrist's letter evidence. It challenged the airplane demonstrations, and it called a witness who said he believed he had seen Gail after the time Robert said she left. This was not a case with forensic certainty. It was a case about whether absence plus contradiction plus capability became proof. The hardest part of the record is the testimony about Gail's fear. Hilliard Weiss, Gail's cousin, testified that in the fall of 1983, Gail reported an argument in which her husband choked her to unconsciousness. Her sister Elaine testified that Gail called her extremely upset and said Robert had tried to strangle her, that she lost consciousness, that he revived her and apologized. Dr. Lee McCullough, Gail's employer, noticed bruises on Gail's neck. She testified that Gail said Robert had gotten angry and choked her because she had been smoking a cigarette. Other friends and colleagues described Gail saying she was afraid of his temper, that he was controlling, that she was considering separation. Some testimony concerned an alleged letter from Robert's psychiatrist warning Gail about his dangerousness and suggesting separation. Witnesses said Gail planned to use the letter as leverage in divorce proceedings by threatening to use it to damage his career. These statements carry emotional force. They also carry legal risk. The confrontation clause issue would later become part of Robert's federal habeas petition. The Second Circuit ultimately affirmed denial of relief, but the issue itself shows why source labeling matters. Gail cannot be turned into a character who says lines we invent. Her statements in this episode remain what the record says witnesses testified she said. That is narrower, it is less dramatic, it is more honest, and within that narrow frame, a pattern emerges in the public record. Fear, plans to leave, alleged violence, and a final weekend when Gail told a friend she was looking for another place to live. At trial, the airplane evidence did not stop with rental records. Dr. Charles Hirsch, the chief medical examiner for New York City, testified that before rigor mortis, a dead body is pliable. The body of a woman 5'3" and about 110 pounds could be folded and tied into a package about 36 inches long. He also said a body could be disarticulated at the joints, a process that someone trained in anatomy could accomplish in about 10 minutes. That testimony is grim, but it was presented to address feasibility. Could a body be made small enough to move and dispose of? The jury also heard about heavy duffel bags and about the Cessna 172 Skyhawk. An FAA inspector testified that a pilot could single-handedly dispose of something from the plane without great difficulty. During the trial, Sergeant Matthew Rowley of the NYPD Aviation Unit flew 3 demonstration flights in a Cessna 172. He loaded a bag containing 110 pounds of sand and rice, flew over the ocean, and ejected the bag using different maneuvers. The performance was videotaped and shown to the jury. The defense challenged this evidence on appeal. Demonstrations can be powerful. They can help jurors understand a theory, but they can also risk turning possibility into seeming proof. The appellate division held the evidence was admissible. The court saw it as relevant to feasibility, but the limitation remains. A demonstration is not the same as a recovered body. It shows that something could be done. It does not show that it was done unless the rest of the evidence carries the burden. The prosecution also relied on Robert Bierenbaum's changing and inconsistent statements. The core inconsistency was the hidden flight. In detailed early accounts, he said he stayed home until about 5:30. The record says he was already flying by 4:30. There were other accounts too. About 3 weeks after Gail disappeared, Robert began an affair with Karen Caruana, a nurse educator at Maimonides. Caruana testified that he told her his apartment and car had been searched and that he was clean as far as any police investigation was concerned. She said he told her that before the end of September, when the police had not yet searched the apartment or car. He told Caruana he had hired a private investigator who found evidence Gail was in California. He told the owner of a vacation rental that Gail had a drug problem and disappeared with drug dealers. He told another renter that he went looking for Gail in Central Park, found her towel and suntan lotion, but she was gone. Gail's therapist denied Robert's claim that she had told him Gail was very depressed and might hurt herself. A friend noticed that the living room rug was gone days after Gail was reported missing. Robert said the cats had fouled it and it was being cleaned. Years later, another partner testified that Robert said Gail had a drug problem, extramarital affairs, and that her death was drug-related. Different explanations do not automatically prove murder. People lie for many reasons. People speculate under pressure. But in a circumstantial case, inconsistency can become a map of consciousness of guilt, especially when the omitted fact is an airplane flight on the day of the disappearance. A fair account must give the defense its place. The defense called Joel Davis. He said that on the afternoon of July 7, 1985, he had been in a bagel shop on 2nd Avenue in Manhattan and noticed an attractive woman wearing a distinctive T-shirt with a non-English word on it. 2 weeks later, he saw posters of Gail and identified her as the woman he had seen. He called police. If believed, that testimony could support the idea that Gail was alive after leaving the apartment. But cross-examination exposed problems. Davis admitted he had told a defense investigator that the woman was tall and statuesque. He explained that he had confused his description by comparing the woman to 2 different women, one tall with her face and one short with her body. The prosecution called Gail's sister Elaine as a rebuttal witness. She provided a picture from the summer of 1985 and described Gail as less than 5'3", about 110 pounds, with an A-cup bra size. The defense also challenged the state's legal architecture. It argued the conviction was not supported beyond a reasonable doubt. It argued the jury should not have heard certain statements attributed to Gail. It challenged the letter evidence and the airplane demonstration videos. Those challenges matter because they show the case was not simple. It was an accumulation case, and accumulation cases are always vulnerable to the question, are we adding proof or are we adding suspicion? The jury found proof. The appellate courts allowed that verdict to stand. The jury convicted Robert Bierenbaum of second-degree murder. He was sentenced to 20 years to life. On direct appeal, he argued that guilt had not been proven beyond a reasonable doubt and challenged several evidentiary rulings. In 2002, the appellate division affirmed. The appellate division's language was unusually forceful. It said the circumstantial evidence excluded beyond a reasonable doubt any reasonable hypothesis of innocence. It rejected the sufficiency and weight challenges, and it upheld the admission of the disputed evidence. leave to appeal to the New York Court of Appeals was denied in 2003. The United States Supreme Court denied certiorari later that year. Robert then filed post-conviction motions and eventually a federal habeas petition. In federal court, he argued ineffective assistance of counsel and a confrontation clause violation from the admission of Gail's out-of-court statements. In 2010, the Second Circuit affirmed denial of habeas relief. The federal court did not retry the case. It reviewed under habeas standards, which are deferential to state court adjudications. That distinction matters. An affirmed conviction is not the same as a fresh jury hearing every fact. It means the legal challenges did not meet the standards for relief. The outcome remained, a conviction for the murder of Gail Katz Bierenbaum in a case where the body was never found. This case lasts because it asks how much weight absence can carry.
There was no body.
No confession. No recovered weapon. No forensic match from the aircraft. No eyewitness to a killing. But there was a woman planning to leave. There were statements admitted with limiting instructions about fear and alleged violence. There was a husband's story that put him in the apartment until 5:30, and a rental record that put him in a plane by 4:30. There were changing accounts about depression, drugs, California, Central Park, and water. There was a demonstration showing feasibility. There was no verified sighting after July 6th. The prosecution asked the jury to see a whole picture. The defense asked the jury to see gaps. The courts ultimately held that the picture was enough. For Gail, the public record is painfully indirect. We know her through appointments she kept, plans she made, statements others testified she made, and the silence after July 6th. We know she was studying psychology. We know she was looking for a way out. We know her family called detectives repeatedly in the first week. We know her body was never recovered. A true crime episode can be tempted to make that absence cinematic. But the better choice is restraint. The absence is not a mystery box. It is the center of a family's loss.
Ledger Item 1. Tag. Court-fawning. Robert Bierenbaum was convicted after a jury trial of second-degree murder and sentenced to 20 years to life. Source: Bierenbaum v. Graham, 607 F3D 36, lines 8 to 11.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger Item 2. Tag. Court short fun. Gail Katz Bierenbaum was last seen on July 7, 1985. Her body was never found. Source: Bierenbaum v. Graham, background.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger Item 3. Tag. Fact. Gail Katz and Robert Bierenbaum married in August 1982 and lived in a 12th-floor apartment on East 85th Street in Manhattan. Source: Bierenbaum v. Graham, background.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger Item 4. Tag. Fact. Robert Bierenbaum had graduated medical school in 1978 and was a surgical resident at Maimonides Medical Center. Gail was pursuing a PhD in clinical psychology at Long Island University. Source: Bierenbaum v. Graham, background.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger Item 5. Tag. Fact. On July 6, 1985, Gail kept a gynecologist follow-up, made a later appointment, kept a hairdresser appointment, met a close friend, and said she planned to leave her husband that weekend. Source: Bierenbaum v. Graham, disappearance section.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger Item 6. Tag. Prosecution. The prosecution theory was that Bierenbaum murdered Gail on July 7, 1985, disposed of her body, and concealed the airplane flight from investigators. Source: People v. Bierenbaum, Bierenbaum v. Graham.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 7. Tag. Court FCING. Bierenbaum told police he had remained at home until about 5:30 p.m. before leaving for New Jersey, but investigators later learned he rented and flew a Cessna 172 from Caldwell Airport that afternoon. Source: Bierenbaum v. Graham. Investigation and inconsistent statements.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 8. Tag. Court sinning. No one other than Bierenbaum reported seeing Gail after July 6. Source: Bierenbaum v. Graham, line 29.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 9. Tag. Courtgin. Police searched between the apartment and Central Park and found no trace of Gail. Source: Bierenbaum v. Graham. Investigation.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 10. Tag. Courtfångning. Courtwing. Nachdotcheck Bierenbaum. Ledger item 10. Tag. Courtfångning vergefold element portion. It's not chanstamella new 4 days of other time. Ledger item 10. Tag. Courtfångning GANEM. Bierenbaum first for lived and watch them for this. Might procreated. It's not chanstamella by level and then jump for them pitta enjoy tivit. It really is a track. They hoped you involved in 24,000 of joyed. Ledger item 10. Tag. Courtfångning 10. Bierenbaum. Ledger item 10. Tag. Courtfångning 10. Courtfångning eat pretend and the joyed. Ledger item 10. Tag. Courtfångning eat pretend the joyed. Bierenbaum first pretend it's not chanstamella new 4 days of a time. Ledger item 10. Tag. Courtfångning 10. Bierenbaum. Ledger item 10. Tag. Courtfångning eat pretend the joyed. Bierenbaum open it. Just a way that them first in more than 10. It's never concerned. Ledger item 10. Tag. Courtfångning eat pretend the joyed. Ledger item nen have eat pretend the joyed. Ledger item 10. Tag. Courtfångning eat pretend the joyed. Ledger item lead atom. Ledger item lead. It was Y in the troth ground ledger item, and it was right that most follow tranksing outside if the grounder. Ledger item 10. Tag. Courtfångning eat pretend the joyed. Bierenbaum open it. Ledger item 10. Tag. Courtfångning eat pretend the joyed. Bierenbaum open it. Lead atom because it was Y in the 14 millionth bevidet. Ledger item 10. Tag. Courtfångning eat pretend the joyed. Bierenbaum open it. Lead. Ledger item 10. Tag. Courtfångning eat pretend the joyed. Courtfångning lead 1. Fortfarande inclusal fars after the fortfarv. Courtfångning enk in 9. Might first of what's of something, it they omit that the sublitic that joiter is forthant. One of the first and fortfars weather, they don't know a cover its every main, it's the list of no sight, and then it first forthant. Fort, not first is effect, it was judge me to Carlote. Fort forces, it for you and every single live, it was no much and medge and a march, and then if they is it was brothered. Fort forces, fort next live, it was never recog nothing. Fort fargers, it for you, it was in the live. Fort forces, it's never good and live it for you, in every men. Ledger, it's got in Tamal, it first of, next live, it for you, it was great division, it's the likely manjid believe, and everything thevra. Ledger item, 10, third, 8 per 10, the joyed. Fort forces, it for you, it's never good and live it. Fort forces, it for you, it was in the live. Fort forces, it for you, and every men. Fort forces, it for you, it was one and live it, it's not every men. Fort forces, it for you, it was in the live. Ledger item 10, tag, court, fonding. Bierenbaum first said a building doorman had seen Gail leave, then said the doorman thought it was another day. Source: Bierenbaum v. Graham, investigation.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 11, tag, court fanchal. Courtfanchal.com, not no certainly, is it Court Fanchal? When asked if he first they forward to Levant ledger, item 11. Nudge no it enough of the fact that ledger item 11. When asked if he would be the trun of there is the court for linging else, it was a $5 of court fanging. When asked if he would follow 8 to them that their fort have got the mid done the job, and it perts this court is the friend. When work that they ask it into them is the leaven. Now if there is protracted by charging is the breathet, and there had seen them every match, it for mote self. When asked if he would be in choice rover if those of jobs will give trunked out, and for those had been change. Next at that charges will actually ned that they for the memories it build between job or med, amongst being more emojing to for that liz, it we want to match my job, it's critically is. When asked if he would be never quite that the charging read, if we want to make that med is the flies really there. When asked if he was read that there had seen them put their a matcho into the charging. Now if this who is the growth which have surded that they did that there be a measured just to the month of much wares, they want to be just it the lead at. Ledger item 11, tag, court item, tag, court funging. When asked if he would forgive it to court funging, it specially reddited that therefore the men trucked out the grot. When asked if he think of it its interest, if they fate flew that tried to make stabbed out, it may be just. Now definite that they walked the gatter even where the references it from May Christovals. Now today if they found into this bed, it was whether into their 4 things were in far that the events which works for this, if they do have that way, they found into the listic work for what they also get a. Charger, it's barger item 11, tag, courting. When asked if he had ever choked Gail to unconsciousness, Bierenbaum said he did not want to speak about that. Source: Bierenbaum v. Graham, investigation.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 12, tag, court fording. A district attorney investigator learned in 1986 that Bierenbaum had rented an airplane at Caldwell Airport on the day Gail disappeared. Source: Bierenbaum v. Graham, investigation.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 13, tag, court functions. Forensic examination of the aircraft and 2 automobiles yielded no results. Source: Bierenbaum v. Graham, investigation.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 14, tag, fact. A torso found on Staten Island in 1989 was initially determined by X-ray comparison to be Katz, but after the investigation reopened in 1998, DNA comparison determined it was not Gail. Source: Bierenbaum v. Graham investigation.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 15. Tag: Court faculting. The indictment for second-degree murder was returned December 8, 1999, more than 14 years after Gail disappeared. Source: Bierenbaum v. Graham investigation.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 16. Tag: Court forwarding. 11 witnesses testified about Gail's out-of-court statements regarding the marriage, fear, alleged choking, threats, and her plans to leave. The trial court gave limiting instructions. Source: Bierenbaum v. Graham, Katz statements.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 17. Tag: Alleged. Several witnesses recounted Gail saying Bierenbaum had choked or strangled her during a 1983 cigarette-related argument. Source: Bierenbaum v. Graham, Katz statements.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 18. Tag: Alleged. Witnesses recounted Gail saying she had received a warning letter from Bierenbaum's psychiatrist and intended to use it as leverage in divorce proceedings. Source: Bierenbaum v. Graham, Katz statements.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 19. Tag: Court final ing. Medical examiner testimony described how a body of Gail's approximate size could be folded into a 36-inch package, and that a person trained in anatomy could disarticulate a body at the joints. Source: Bierenbaum v. Graham, videotapes.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 20. Tag: Courting. An FAA inspector testified that a pilot could single-handedly dispose of something from a Cessna 172 without great difficulty. Source: Bierenbaum v. Graham, videotapes.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 21. Tag: Courting. During trial, an NYPD aviation unit sergeant flew 3 Cessna 172 demonstration flights using a 110-pound bag of sand and rice. The jury saw the videotapes. Source: Bierenbaum v. Graham, videotapes.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 22. Tag: Court filding. The Appellate Division held the circumstantial evidence, attentively reviewed and critically assessed, led to the inescapable conclusion that Bierenbaum murdered Gail and excluded any reasonable hypothesis of innocence. Source: People vs. Bierenbaum, 748 NYS 2D 563.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 23. Tag: Defense_Niduk. The defense challenged proof beyond a reasonable doubt, the admission of Gail's statements, the psychiatrist letter evidence, and the airplane demonstration videotapes. Source: People vs. Bierenbaum, Bierenbaum vs. Graham.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 24. Tag: Defense pedgements. At trial, the defense called Joel Davis, who said he believed he saw Gail in a Manhattan bagel shop on July 7, 1985. Cross-examination exposed inconsistencies in his description. Source: Bierenbaum v. Graham, defense.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 25. Tag, court. The appelletet utforning. The appelletta was followed division affirmed the conviction in 2002. Leave to appeal and certiorari were denied. Source: Bierenbaum v. Graham, post-trial proceedings.
We keep that wording narrow because the record supports the claim in that form and not beyond it.
Ledger item 26. Tag, court utforning. Ledger item 26. Court ringing forming. The Second Circuit affirmed in Standling complete story in this court fine. The Second Circuit affirmed that jumukal fining and the level fought, which was general fawning, the general fawning in 2.2 of the level earlier. The Second Circuit affirmed that this was what the biggest affectation in free damage 20 in this well. The Ledger item 26. Tag, court fining in 26, the next 24 jumel fawning. The Second Circuit affirmed that jumel fawning in 2.2 in this well. The Second Circuit affirmed that this was what the biggest affectation in free damage 20 in this well. Ledger item 26, Thag, court, item. The Second Circuit affirmed that this was what the level fawning, which was general fawning. The Second Circuit affirmed that this was what the biggest affectation in free damage 20 in this well. The Second Circuit affirmed that this was what the biggest affectation in free damage 20 in this well. The general fawning in 2.2. Example, this was private carrying everything that several gruth of the general solo. This one where use it with a 19%. The general fawning in general court fining in 2.14 in this well. The ref dropped of human for this new part of general fawning and also 3 general that this was what the biggest affectation in free damage 20. The government circuit has been drobbelied in 24 into this well. The drevel fawning for standing 21 and the ref dropped of this is a court again in detail. It's a bit of the quarter for that point in the ref dropped of. The drevel fawning is now character. It's also bringing for many from the first 14 states of now. It's being jumpward, it not start in this welladies. The devil fawning that the level fawning in 2.3, it's just what of every people have, it's still to be the data. The pout 4 is a way to court general fining. It is inextrepted, but for them they ward way. The devil fawny 4 that they're reproved in part of the good one. The glibret chapter they're reading a big grout, as well there's 4 in another proved it parter of the tense of general fawning. In well day, the what proved it plays in 2020 ret. It's not something. It was revolute in 26. It's the brevet it was really doubt. The Second Circuit affirmed it's gated an aggroupment by Goodert, the court finding apparently read, and Double, it's local to big general. The general is, it's better be different each thing in short, and it was the gross dissemport about this 4. The 4 Westphaloning setter that will be para for the world apparently in some, and this 1.23, it was bought of to the big nice of this well, and this is a good one they wert for the government. It's goated all different fours. The graphics 1 type of cart, a low that country down word, and that word is what the different is. It was not for that they brute through the metal word because they wert for the different mart. It we help their brute from deglism for people, it may be a brother today to such. There's well a private brotter in the month moment for the graphics, it can't be ifitedly 10. It was not being particular in the most aft of all the different for word, and there another such the word with the biggest with the graphic. The back through that the most of the evident, it was not for, it start, are they ready board parrotly in the small. It was not right their right, it's the move that this why, or that they wert from the graphic in the developed. The devil was also cleared about that court again in the vide of a graphic, and also created by rid in the crypt of Clart. That word that they wert from becomensa either the different force in the graphic, it was also retted by the lead at round. The graphic forward, it begins to be biggest out reduced the graphic, it's also cleared about that quote again. Ledger item fought with the graphic, it was not taking about what, it doesn't seem that this was while able to fund it again in the sleet. If the part for that they don't do about a graphics into the graphic accident, it was being created and other things of the graphic. The draver may prove the graphic that would having a goodment in the graphic. It feel that they sinter a 1940. The ledger item for with the graphic, it was just for, it was just every people. The Second Circuit affirmed denial of federal habeas relief in 2010 on ineffective assistance and confrontation clause claims. Source: Bierenbaum v. Graham, 607 F. 3D 36.
We keep that wording narrow because the record supports the claim in that form and not beyond it. A note on circumstantial proof. In everyday speech, circumstantial can sound like weak proof. In court, circumstantial evidence can be powerful. It asks jurors to infer one fact from another. A rental record can establish a flight. A false timeline can suggest concealment. A pattern of statements can suggest a story being adjusted. But every inference still has to meet the burden of proof. In this case, the appellate court held that the inferences were strong enough. The defense argued they were not. That tension is why the record has to be read slowly. No body cases are difficult because the state cannot rely on remains to prove cause and manner of death. Prosecutors usually have to build from disappearance, motive, opportunity, conduct after the disappearance, and evidence inconsistent with voluntary absence. The risk is obvious. A missing person is not automatically a murder victim. The safeguard is the burden, proof beyond a reasonable doubt. The appellate division concluded that burden was met here. This episode does not add imaginary evidence to make the case easier. It stays with the public record. The testimony about Gail's statements was central and contested. The trial court admitted it for limited purposes and instructed jurors not to misuse it as propensity evidence. That legal detail matters because emotional testimony can overwhelm careful reasoning. The law tries to narrow how jurors use such statements. On appeal and habeas review, Robert Bierenbaum challenged the admission of that evidence. The conviction survived those challenges, but a responsible retelling still labels those statements as testimony about statements, not as direct recorded proof. Gail Katz Bierenbaum was last seen in the public record as a woman with appointments, studies, friends, plans, and a decision forming. She was going to leave. The courts did not recover her body. They did not produce a single simple exhibit that solved everything. They affirmed a conviction built from the shape left around her disappearance. A missing flight in a husband's story. A small plane from Caldwell Airport. A timeline that changed. A fear that witnesses said Gail had voiced. A defense that argued doubt and challenged the evidence. A jury that convicted. Appellate courts that let the verdict stand. The public interest question is not only whether one man was convicted. It is how legal systems handle intimate partner violence allegations, missing body prosecutions, hearsay safeguards, and the slow work of proving a death that someone tried to erase. Gail's absence became evidence, but before it was evidence, It was a human absence. A daughter, a sister, a friend, a student, a person trying to leave. Please like and subscribe for more.